Good morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Tuesday, March 25th, 2025 at 9:05 in the morning. So we're here to begin our day looking at H 342, which is an act relating to protecting the personal information of certain public servants. So I think when we left here Friday, we thought we may have had breakthrough, uh, especially when we were talking about injunction and injunctive relief. Uh, Over the weekend, discussions that continued to have with Ledge Council, we understand that that's probably not a good path to go. So we've continued to work. We thank you, Rick, for working with us Sunday night, last night. So we have a proposal that we'll bring to the committee. Rick will walk through it. It's still a private right of action, but with safe harbor built in that I think could work for the good actors, the bad actors, maybe not so much. And I think those are the ones that we're trying to get at anyway. So I guess, Rick, if you can walk us through this new language. And then we can find out. We will delay action on this for 2 more legislative days so that we have time. I think we need to have the study language in there. We do need to talk to the administration, the agency of administration and others to at least let them know what we're doing. And so they're not taken by surprise when they see this. So we should have those conversations with them and the LCT and others as well. So, Rick, welcome and thank you for joining us.
Yeah, good morning. Rick Sagal, Office of Legislative Counsel. You should have 1.3 of this. I'm not sure what to call it yet, and we'll figure that out once we know what the committee wants to do. So right now it's just the chair's amendment, but I just did that as a placeholder. Ideally, more of you would be on the amendment. And just kind of give a background of what we're doing here and how we got here. Remember that 342 came out of committee. Was it last week? Early last week. When it came out of committee, it went to the House floor. It passed, and it was due for 3rd reading late last week. You received an amendment from Rep. Harvey. That amendment was walked through on Friday, and there were some maybe not total agreement with the amendment terms. So the committee decided to amend its kind of more of its original report that it passed out of this committee. So there may be a couple things that were in Rep. Harvey's amendment that have made it to this version of this amendment. But what this would do is if enough members support this, it would be a substitute amendment on the floor, which would take place of either Rep. Harvey's amendment or the House original House report of the bill. Does that make sense? For me, also, this helps me to kind of figure out where we are today because things have happened since last Tuesday. I've tried to highlight everything I did, but I didn't get to everything. I'm going to walk through, and I don't have a side-by-side, but I will do my best to kind of show you what has changed since Friday. And obviously, there'll be some talking points. Nothing changed with the findings. Again,
Rick, could you just go over the reasons why we chose not to go with an injunction?
You gonna start with that? Sure.
Before we start with
Sure. So injunctions, first of all, are fairly new to me. I'm not on the judiciary team, and I'm not too familiar with the standard needed to get an injunction, the cost involved, those kind of things. So I spoke to my colleagues and researched it a bit more. And typically what Vermont law does is they give an injunction as one of the many options a person has. If you've been harmed through various laws of Vermont, you can usually request damages, request an injunction, or declaratory relief. Those are usually your options. Occasionally, we limit it to injunctions. The issue with this law and injunctions being the only option is, let's say a person's information's out there and they ask for it to be removed from the internet. The company doesn't do it, data broker doesn't do it. At that point, the person's only recourse would be to file an injunction, which costs $700. They would likely have to hire a lawyer for that. So they file that. and then let's say the data broker responds to it and they take it down, it works, right? And the person gets their attorney's fees, their court costs. But the problem there is, would attorneys actually take that case? There's not really anything of value for the lawyer except for their attorney's fees to take it on. Normally, lawyers want something, a reason to take a case, which is it's money, right? They run a business like everybody else does. So just having an injunction as an option is really limiting for the covered people because they may not be able to find a company or a lawyer. And if you talk about companies taking these on, companies will hire lawyers, right? That's how this thing works. So the company won't be able to find a lawyer to help them proceed with the claim if it's just an injunction. So I talked to the committee about or the representatives of the committee about that, and it was decided that this bill really wouldn't have much. What's the word I'm looking for? Punch behind it if it's just an injunction. And also, a lot of these data brokers may not actually respond to an injunction. So the thought there was that hit them where it hurts the pocketbook, which would require some level of damages.
Was that a little bit about irreparable harm too?
So the standard for an injunction to grant them is irreparable harm, which means the court would have to basically see that there's no other recourse for this person besides granting them an injunction. It's a very high standard. It's higher than just usual preponderance of the evidence, right? Usually when you go to court, if your evidence is better than the other person, you win, right? For an injunction, the standard is you must be harmed in a way that money can't help you. And only upon that finding will the court actually issue the injunction. So in addition to what I said earlier about it not really being a big thing for attorneys to take, it's also a very tough thing for attorneys to win, is you must show. And with this law, your information being online, is that really irreparable harm if they don't take your information down? It's up to the judge or jury to determine that, usually a judge in this case, but that would be hard to prove, I think.
Questions for Rick on? You just have one?
Yeah. Yeah, I mean, I get it. Always in business. We might not like, some of those business aspects, ambulance chases or whatever, but there's still, those things are in place to motivate an attorney to take up the case. Because they'll get compensated beyond just the returns.
And if it's only an injunction, then it's going to be even less ideal for a lawyer because what are the odds we're going to win this? So you know, I'm going to decide not to take your case because I won't get my attorney's fees because I have to prove this harm is irreparable. So
I think too, if they're engaged with their client, and I think the thing that they're gonna have to tell their client is that it's very unlikely that you're gonna be able to get an injunction.
if you're being honest with your client, yeah, which you should be.
Right.
Anything else about injunctions, or shall I move on to the changes? Okay. You may remember under the definition of covered person, we had a discussion about the currently or formerly. So I didn't add or remove any people. I did restructure how we organize this definition of covered person. So you'll notice now it says means any of the following individuals who are either currently or formerly. And it goes down the list of various people, various positions. You can read that and see if it makes sense to you. But now it's currently or formerly any of these individuals in these positions, judge, law enforcement officer, and so forth. I also had to remove immediate family to a different part of the definition because you don't want them to be formerly current immediate family. So the current or formerly does not apply to immediate family. There just have to be immediate family to be covered. Any questions about that?
Was it and I'm trying to sort out the list here.
Mhm.
Was it intentional? I think this doesn't include the investigators who work for the public defenders, but maybe I got it.
So on line 15, 333, or III,
Yeah,
I believe that covers.
I just don't see defenders in double I.
You mean Defender Generals?
Number 15.
Yeah,
Investigator.
they're defined later in the bill.
Right, but they have, it looks back for any of the entities listed in subdivision 2. So they'd have to be. Am I reading this wrong?
Oh, so
Wait, what was line 18, maybe?
he's talking about, I think I know what he's talking about, public defender, investigators that work with public defenders.
Right.
Okay.
Maybe I'm just reading it wrong.
No, you're correct. They would,
I guess, does this also get back to the contractor issue?
it says, so in that line 16, employed by or works on a contract basis.
Okay.
Yeah,
Okay.
but
I'm willing to let, let's move on. I mean, I think it's important, but at some point, if we got time.
they could also, yeah.
Yeah, page 3, line 3, federal law enforcement officer, is there any need to specify that their place of employment had to be in Vermont?
So
Is
it
that-
is, later on the next page,
Okay,
or
thank you.
let's see, where is that? Yeah, page 4, line 11. Limited to those individuals who work or reside in
Okay,
Vermont.
I'm sorry. I
That's okay.
Didn't read down for Arnold.
Okay, I'll keep moving on then. No other changes to the definitions. So we get to subsection B, your favorite subsection, actually C is your favorite subsection. The non-disclosure of protected information. No change to 1, that you have the right to send a notice to a data broker, that's still there. 2, upon the no new language here, upon a data broker receiving the notice, they have 15 days from receiving the notice to stop disclosing and not redisclosing the information after that time. Okay, 3, there's some reorganization here. This is the Secretary of State providing the form for the person to submit to the data broker. So it must be in a form provided by the Secretary of State, except that no prior verification of a covered person or authorized agent status shall be required. That didn't change. And the notice shall include a disclaimer that ceasing disclosure of a covered person's protected information may complicate certain business transactions. So this was brought up last week about some kind of just a warning acknowledgement that if you do this, there could be some unintended consequences that may complicate. It doesn't really change anything, but it hopefully gives the covered person a heads up that there could be an issue with certain transactions. Good. Okay, remedies. I've added new language subject to the exception in subdivision 2 of the subsection, which we'll get to in a second. A data broker that receives a notice from a covered person or their authorized agent that discloses or rediscloses the covered person's protected information more than 15 days after receiving the notice is in violation of the section and is subject to a civil action brought in Superior Court by the covered person for damages, injunctive relief, reasonable attorney's fees, and court costs. So this differs from what your report was. If you remember, the committee report was liquidated damages at 1,000, right? Or actual damage, whichever is greater. Punitive damages, injunctive relief, right? You had a kind of a bullet point list of options. So the Harvey Amendment did not have damages. It was just going to be some type of injunction. So this would be a place if you want to discuss any changes or additions to the rights that a covered person has in court.
Yeah, Rick, so we talked about the irreparable harms piece, like that bar being too high. I'm wondering, so getting rid of liquidated damages and just having damages, this is one that like on the privacy bills in general, trying to have people prove damages, especially when they're just trying to get their information removed. I'm just wondering, like, this bar still feels too high, as far as like curious for your thoughts on why or if a lawyer would be any more interested in taking this on for somebody. Yeah.
Right. So I can't speak for all lawyers, right?
Sure, just type it out.
Like I said before, what's the damage here? Like if you sue and you hire a lawyer, clearly you have attorney's fees, you have court costs. But what are your actual damages for your name being out there and your information being out there? How much is that worth? And it is kind of fact dependent, but if you haven't been swatted, if you haven't really had any other harm besides just your information out there, it's going to be nominal probably. I mean, and by nominal, I mean,
It might be nothing, right?
it might be nuts. Yeah, I mean, so you would have to argue to the court that your damages are real. And like if you went to the hospital because you had a mental breakdown or something, right? That could be damages, right? Because your information's out there. But again, really, really fact dependent. And I think most lawyers would have a hard time, not just with the injunctive piece, but if you just say damages, how have you been harmed is my question.
And you could, it's okay, fine. And we're saying like this data isn't just in like one good or bad actor like Databricks. This could be in tens, it could be in hundreds, it could be in thousands of different places. So you're going to have to file all of these kind of notices and then follow up on them and pay courts and attorneys fees to track down each one for the chance of damages being proven in any one of those cases, versus the liquidated piece of getting something like.
Yeah, I guess it helps if you think that way, that if you're trying to remove, more than, I always think of just one, right?
Right, but it's not.
There's just one bad actor, but if you're trying to get several data brokers to remove your information and they don't, then, for one person to do that, yeah, I mean, your damages will go up, but then you're also suing more defendants. And I don't think it's going to go up in a way that's like significant to you as a way to make it worth your time or worth the attorney's time. But that's more of my personal opinion, probably.
So in like thinking about the number of entities that somebody might have to go through, and that's basically the hoops they're going to have to go through. If it doesn't make sense necessarily or attractive enough for a lawyer to go for damages, like I think in this case, we need people to be able to have lawyers who are helping them, like talking around with some people, like the good actors, it is likely that it might take like a few days to get served and it might be a couple $100. So like, as far as what they're paying, if they're making changes in good faith and that kind of stuff. But if they're bad actors, like they might be anywhere, and it sounds like it could take months for somebody to track them actively down to serve them, and then thousands of dollars to track those down. So the people were the entities were, I think in this case with like what ended up being more on a secure period, we're giving the good actors like a pretty reasonable, low cost, window to like pretty inexpensive to like fix. But when it comes to the bad actors, like we're really kind of stringing people out, I feel like, and not giving them access to resources to help them, which is kind of the whole point of this.
Yeah. I can't probably.
Yeah,
that
that's fine.
Yeah. Understood.
The purpose is to compliance. Why wouldn't we set it up so that somebody could report it to, I'm assuming it would be the Attorney General, correct?
It could be. Yeah.
And then apply a fee for every single day that the information has not been removed. And it's an escalating fee. After 15 days, they say it's like $100 per day. After 15 days, it goes to $500 a day. After 30 days, it goes to $1,000 a day.
Yeah.
And all that money just gets put back into the general fund or a fund to you know, for victims.
right?
Or to fund the position at the.
I was gonna say, how much
Or-
money? How much money we give the AG?
So the committee kind of talked about that, right, on Friday, the fine piece. And, you know, it's a decision that the committee would need to make as far as change that the big change going from civil action to a fine-based model where, you know, the AG or state's attorney's office is fining the entity. I don't frankly know if I think you might want to hear from them and see how easy it would be for them to accomplish that. Like, would it work? Like, would they be able to get the money from the data broker using that method? I don't know, but it's an option. The fine model versus the right of action model.
Thinking a lot about this. And, you know, it's all about how do we devise a mechanism that's both effective in vindicating someone's right, personal right, and, you know, effective in terms of deterrence. And I came up with about 5 or 6 options, but not all of which are on the table here. But the AG issue, you know, was kicking around because we have a lot of statutes where you both confer on an individual their own ability to sue, as well as also authorize the Attorney General in certain cases, well, as just as a general alternative to do the same thing. And that sort of aspects gets you over a bit of the hurdle of how you're going to get an attorney to vindicate your rights. And we do that a lot, you know, in a number of different Title IX statutes where, again, I have no idea what the Attorney General thinks about that or how they would manage to fund it. I always like bill backs, but you know, how they would handle that. Anyway, that was part of my thinking about it. And I agree it's kind of fine, just plain fine. Probably doesn't give motivation for, you know, an attorney to pick up the case, whether it's damages or injunction. But maybe I'm wrong, you know, that's just my sense.
That's something we'll have to have a conversation with the Attorney General on. I mean, I like the idea of a fine. It's we have an agency or department that does that when we business.
That would require a lot, you know, a lot more discussion. Although I'll keep thinking about it.
Shall I continue? Okay. So subdivision 2, this is a new subdivision. A data broker that ceases disclosing the protected information of it, this is the safe harbor, of a covered person not more than 15 days after being served with process in a civil suit brought by the covered person shall only be liable to the covered person for reasonable attorney's fees and court costs in the civil action. So let's say you send a data broker the notice, they don't respond to it, they keep disclosing, then you sue them after 15 days. And 15 days after that, let's say you sue them, they get served, okay? 15 days after that, they still are disclosing information. They would not be eligible for this disclosure for the safe harbor. However, if within 15 days of being sued, they do stop disclosing, then they would only be liable to the covered person for attorney's fees and court costs. So no damages. It gives hope. I think the idea is it gives the data broker a reason to comply upon getting served with the complaint. Any questions about that?
So they got a safe harbor of 15 days.
From being served.
By the time they're being served, they've been served.
Yeah, from the notice.
So,
Not from
no,
the
no,
notice.
when they're served.
The process, yeah.
So it could be a matter of
15 plus 15.
plus, well, it could
Could
be
be months.
15 plus a few days, it could be
Right.
15 plus months.
Okay,
Yeah, they'd have to get, I assume.
I see.
Yeah. Yeah, the 15 days is duplicative here. You get 15 days from the notice initially, it's formal, but it's not a court proceeding, right? And then if they don't act within 15 days, you can sue them, you serve them, and then they have 15 days to comply with that. If not, then subdivision 2 does not apply to them.
And if you remember right, the 243, what we just went through with the Secretary of State's office, corporations have agents, right? None of these data brokers are in Vermont. They're incorporated in other jurisdictions, so they would have to find out where they're incorporated and find out who that agent is and serve the agent with the note, with the civil complaint.
Okay, subdivision 3. A data broker is not eligible for the safe harbor exception if the data broker, A, not earlier than 15 days after receiving notice from a covered person or their agent, discloses additional protected information of the covered person. So basically what this is doing is that if you get not the complaint, not the serving, but when you get that notice, if 15 days after receiving that notice, if you disclose kind of in a retaliatory fashion, additional protected information, you don't get the safe harbor. You're not eligible for it.
Is that retaliatory or is it just additional information coming out?
It's just additional. The intent is that this would be a retaliatory thing that they're doing, but it may not be. It's a fair point. That's the intent behind it. B, so this is the other exception to the exception.
I keep going back and forth with how generous we're being with that cure period, right? Because it could be months. And so if a business is lazy or unable in some way to manage the data that they are supposed to be managing, or retaliatory, I don't think it matters the why. I think it matters the what, right? I think it matters that if they're sharing data that they're not supposed to be sharing, there should be something with some time limit. And I don't, like I said, I think we might be being really generous with the time period. But there should be something that, like, if you figure it out, there are lots of people who've been doing this already. We're not the first, right? So lots of states that are requiring this already. If you can do it and you can protect people's data, that we're saying, please protect these people's data. We don't want judges to be targeted in Vermont. We want them to be able to be in this whole, right? So figure out how to do it and protect these people. Don't let their data go public. That's, is that answering, like, kind of
I was just asking if retaliatory was,
necessary?
I mean, it wasn't, it was just making sure that we're not. I mean, to say retaliatory versus, information that just, these systems, the systems are very, information comes on, it's put out. It's not, so that's the reason why I was asking.
Yeah, I don't think we can judge why their information is going out. I think we just need to say, stop sharing information.
It was just a question about whether or not it was intentional for retaliatory. That's all. There was no.
Okay.
So yeah, and adding the word retaliatory would require the plaintiff to prove it was retaliatory, right? So we can add the word retaliatory.
No, I was.
But it's a good point.
You mentioned retaliatory. I was just
Yeah.
asking because
Yeah.
it wasn't there.
Yeah, and that's a good question because it's not there. The intent is that would cover that, but that word is not there. Something to keep in mind. So or B, remember that the data broker cannot redisclose protected information at any point, right? Once they receive notice. So they're also not eligible for the safe harbor if they redisclose protected information of the covered person after having received notice pursuant to that previous subdivision where the initial notice that they get, not the lawsuit, but the notice that they get from the covered person. So those two things would exempt them from that 15-day safe harbor. Questions about that or those two? Okay. 4 is the same. Ordinary negligence is the standard. That's the same. D is the same. Limitations. I did not add anything to limitations. There was discussion about these legitimate business transactions, and was curious if you all had time to think about how to word that, possibly to exempt those groups.
So I've been thinking about the limitations and exceptions for the business transactions that I've been very concerned about. And I think it circles around fraud and whether or not we could put something in there to have a exception for businesses, legitimate businesses doing checks on for fraud basis.
So a business, so this would not be authorized by the covered person, right? This is some kind of, you have two data brokers doing something legitimate for the purpose of, you said fraud, some kind of fraud check. That's not authorized by the I'm going to keep saying that because that's already protected. So why would two businesses be doing this fraud check without a covered person's authorization? I think you may be on something, but why would there be this business to business fraud check? Is there some kind of request? Is there some kind of is there something else going on that is requiring this fraud check to happen?
I can tell you that the authorization between the business and the person, after you sign the authorization and then the information is removed for disclosure, that ends there. So if a business is doing a fraud check after they close down their disclosure, it certainly, or after they file the disclosure, it certainly would prevent it. But this makes sense as it's coming out of my head, but it may not make sense to other people.
Yeah, I need, so why would a business just be doing like a random fraud check on somebody versus like if I'm signing up for like a credit card or a car or a bank loan or something, like I authorized and I assume the businesses are gonna like do what they need to do to check on me. But like randomly are businesses doing fraud checks on people just for the funsies, I guess. I mean, that sounds worrying.
If there's something connected to the covered person, right? Something that, again, they may not be expressly authorizing that disclosure, but something that they did or have done could trigger a fraud check. I think he has a point in that the express authorization is pretty limited, but I think the problem before, if you say legitimate business transaction, that's way too broad, right? That's like, but if you limit it to some kind of, for the purpose of a fraud check that is somehow connected to the covered person, would that be, again, without knowing exactly,
Maybe I can help with some clarification here. What comes to mind where something like this would happen is in a situation of impersonation. Say, for example, my grandmother gets something from me that says, I need $100,000, I'm in jail. And we're like, well, we're not so sure about that. And I'm a protected person.
right?
I would have no way to verify whether that was really, she would have no way to verify whether that was really me. I mean, in my case, she could call me, but is that kind of where you're getting at? You know, a situation where because if what I could do is, if I was to think like a bad actor, I could get a list, I could figure out maybe the protected people And then I could use their names to try and, or defraud people and say, hey, and if they go and try and verify who I am, they can't. And if they ask me, well, we need your verification, I can say, no, I'm not going to do that. Now, I'm not worried so much about B2B, and I'm not saying necessarily this is a thing that would happen. I'm just trying to rationalize in my brain what you're trying to get at.
So I have a bank account, a local bank here where I'm the primary person on the bank account. And if I pass away, my bank account automatically transfers to somebody. They do not have a business connection with them until I pass. But if there's any type of, they could do, if I could set my beneficiary on my bank account as, he's dead now because Hilton is the country, which is great. Somebody that would be a terrorist or something, that, you know what, I'm not going to win this battle. So
I would.
there.
I feel. Oh, can we change the word express to standing? So like if a bank or whatever, it's like has a contract when you sign up for a bank account, then you're like giving them an ongoing authorization in case something like they do need to do.
Express or standing.
Or yeah, I don't know. Either replace it or something.
Yeah.
So that's in the contract when you sign up for something in order
Right.
for those entities to do fraud checks.
I think that gets
I
close.
like that.
Yeah. Yeah. Was the committee?
Standing, that definitely makes me feel more comfortable.
I think we also need to realize that, there's some responsibility on the person who wants the data protected.
Well,
You know, even-
That's the disclosure.
Added the language.
Yeah.
It's should be on the form that there could be some ramifications for you.
But even in the case of succession, you take I'm joint account on my father's accounts for this very reason. If he dies, I still have access to the money. And so I don't know as if we need to be so hard on people about that, because there's some responsibility there.
I think standing would make me feel comfortable.
For now. Yeah. So B is not new. And that's the only change in limitations would be adding that language. Let me just finish the walkthrough and then we can maybe tie it up. So section 3 is new, but it's not new language. I took this out of the statutory part of the bill and added the session law because it's got a specific date. And once July 1st comes and goes in 2025, there's not really a need to have this in statute. So this is just for procedural purposes that this
Session law.
this is session law, right? That 90 days after July 1st, the Secretary of State shall provide this form. And until then, the covered person can use their own form to notify the data broker.
With secretaries, they have the authority to, look at keep publishing the notice or amending it or whatever.
So we give them a couple directions, so going back to 3, B3, they shall be in a form provided by the Secretary of State.
Yeah.
And we give them 2 directions here,
Yeah,
but otherwise it's going to be up to them to develop that form.
that sounds good.
Yeah. Okay, section 3, then we have 4 forwards brand new. This is the study on public agency compliance. Remember, one of our Harvey suggestions was to require public agencies also to comply with these requirements. The committee was not comfortable with that, so it was asked to be put in a study. So the current language is the agency administration in consultation with ADS and the Secretary of State's office shall conduct a study to determine the various impacts on state public agencies if public agencies were required to conform to disclosure policies set forth in this act. The agency shall meet with and receive testimony from relevant stakeholders in conducting the study, including the Vermont League of Cities and Towns and the Vermont Municipal Clerks and Treasurers Association. The agency shall consider the following in its study. One, if public agencies were required to cease disclosing protected information of covered persons. A, the extent to which public agencies would currently be able to accommodate these requests. B, the fiscal impact on public agencies. And C, whether additional staffing or training would be needed to comply. 2, how other states have implemented similar requirements on their public agencies, including the types of penalties levied for noncompliance. And 3, the feasibility of creating a state office within the agency to manage all statewide requests to cease disclosing protected information. Some states have done this, have created this office, so I figured it wouldn't be a bad idea for a suggestion as to whether that's needed here. The report would be due December 1st, and I have it sent to the GovOps committees because this is, I think, more in their wheelhouse, but up to you all to decide that. The agency shall include in its report its recommendations for legislative action, as well as a suggested timeline for the implementation of the policies on public agencies. Okay.
Representative Harvey's not going to be happy with this. I would just say remove this. I mean, I don't think state agencies are like willy-nilly disclosing information. I might be wrong. But I think adding a study to this is probably not necessary. But that's my opinion.
But
I don't see the benefit, I guess.
his amendment requires that redaction of all state, got all government agencies. in
We're-
Vermont.
We're not taking that up though, are we?
No, but what we're doing is saying we may agree with that, but we don't know until we understand what the ramifications could be. And so we're saying, let us know if it's feasible, what the costs are gonna be, that type of thing. And we talked about this within a year Friday.
Yeah. It's not gonna cause me to vote no on the amendment. I'm not,
Yeah.
it's not something that I really care about. Cause I'm not interested in throwing our public agencies into this. But that's just me.
I would vote to keep it in. I mean, frankly, one of my complaints about this bill from the outset is you're basically putting a Band-Aid on an artery bleed. Data brokers are a very, very small portion of the data that's increased. And my argument through this entire thing has been, yeah, so they can't go on whitepages.com, but they can still go to the local town. And especially when you're dealing with local police, local district, it's not that difficult to figure out where they live. So to me, I think protecting those public records is probably the most important thing, because I think that's where that's where a lot of these bad actors are gonna go. If not first, very close to first. But I think we need to work out because we have to balance that with the public's right to know. So I absolutely feel this study should stay in.
We'll have conversations with AOA and others, see if thoughts are how difficult this would be for them to put together. Go from there. Okay. Any other questions? We'll come back to this after the floor today.
And caucuses.
Yeah.
We're gonna have further discussion. And I know I would like to hear at some point, the AG around. Because I'm not entirely comfortable, my whole thing is, how do we do effective enforcement and deterrence? And, conceptually anyway, the AG would lend some good weight to that. But so I'm thinking in my mind, geez, it'd be good to have an alternative remedy, but obviously we need to.
We'll see who we can get in this afternoon. We'll try to see if we can get Judge Bonnet in. And possibly the Attorney General or somebody from her office come in and talk to us this afternoon.
Yeah, I did.
We'll also need to hear from the Secretary of State.
I might get in touch with the defender, Attorney General. on that issue.
We also need to hear from the Secretary of the Agency of Administration. And somebody from VL. And probably the Works Association, Treasurers Association.
ADS.
ADS. Well, whoever can come this afternoon and then set up others for Thursday morning. Tomorrow morning, we're gonna do CT. Yeah, we already got people scheduled. I don't wanna back out of that schedule. It's hard enough to get them. Okay. Good, so before, after the 4 caucuses, lunch and back in here, I don't know what time that's gonna be. Thank you, Rick.
See you later.
Okay, well,